The Constitution, Lecture 11. My hope is that this will be the last lecture on the Constitution. And in this one, I would like to discuss the Bill of Rights and subsequent amendments of the Constitution. So this one might be a little bit long. On the other hand, I will say up front that most of the content in this lecture is fairly optional. You should know for the exam, you should have a basic sense of the Bill of Rights and also of the Civil War amendments, in the 13 through 15. But I'll try to make this quick. Now remember, the original Constitution did not have a Bill of Rights attached, even though it was kind of a traditional thing. And the framers of the Constitution, in fact, did not think that a Bill of Rights was necessary. And one of the main reasons why was because it wasn't because they didn't care about people's rights. It's that they believed that citizens' rights were actually already firmly protected by the Constitution as it was written. There are two main reasons for this. The first one is that the Constitution actually contains a number of explicit protections of individual rights and liberties already. Right? The writ of habeas corpus can't be suspended except when public safety requires it during a rebellion or invasion. The federal government and the state governments are not allowed to pass bills of attainder. So in other words, basically punish people without them having received a fair legal proceeding. They can't pass ex post facto laws, so people cannot be punished for doing things that were legal when they did them. No titles of nobility can be granted, so you've got kind of equal citizenship. No laws impairing an obligation of contract. Citizens in federal courts are entitled to trial by jury. Citizens in each state have to possess all the privileges and immunities of the citizens of the several states. So there were a number of rights that were captured under that. No religious test for public office. So there were a lot of protections already in the Constitution. And of course, behind these protections also remained the principle of federalism, right? Most states had constitutions which contained bills of rights. So citizens of the states already had their rights protected against those rights being violated by their state government. And the Constitution contains a number of protections, which I just went through. The other reason why they didn't think that there needed to be a Bill of Rights was that they thought that the very principle of enumerated powers rendered a Bill of Rights unnecessary. Because if you explicitly forbid the national government from doing something, like say establish a national church, that might be thought to imply that the government has the power to do anything unless it's expressly forbidden, right? If you start making a list of you can't do this, you can't do that, you can't do this other thing, then you might draw the conclusion, oh, well, so if something's not on the list, that means I can do it. But that has it backwards for the federal government. Remember, the national government is supposed to do only those things it is expressly allowed to do. And so by the very fact that the Constitution does not expressly give Congress the power to establish a national church, that implies that Congress cannot. So they thought you don't need a separate amendment saying Congress shall make no law respecting an establishment of religion, because there's no place in the original Constitution which says that Congress can make laws respecting an establishment of religion, right? You don't need a law saying that Congress cannot abridge people's right to bear arms, because there's nothing in the original Constitution which says that Congress can abridge the right to bear arms, right? Otherwise, what's the point of listing all the powers in Article 1, Section 8? If Congress can do anything that's not expressly forbidden, it's pointless to list Congress's powers. Right? The very act of listing the powers of Congress and saying all legislative powers herein granted are vested in Congress presupposes that the powers of Congress are limited to what is included in that list. And therefore, there's no need to enumerate a bunch of other restrictions. That was part of the argument. Hamilton even argues in Federalist Paper 84, if you wanted to read it, that's pages 509 through 514 in our edition, that a Bill of Rights would set a dangerous precedent because it might create the impression that the government did have the right to do anything that wasn't forbidden, thereby implying that unless a right is explicitly listed in the Constitution, the government has the right to violate it. And that's actually why the 9th and 10th Amendments were two of the proposed amendments, because if you look, the 9th Amendment, this is page 560, says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So in other words, just because a right isn't mentioned in the Constitution doesn't mean you don't have it. right? So that amendment was explicitly there to try to assuage the concern that by enumerating rights, if a right's not on that list, you don't have it. And then the 10th Amendment, of course, says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And that's meant to reiterate or make more explicit this principle of enumerated powers. If we don't give the federal government the power to do something, it can't do it. Right, so even in the act of putting in the Bill of Rights, the Ninth and 10th Amendments were meant to address this concern, to make sure that people recognize that the powers of the federal government are limited, right, and that just because a right's not on the list doesn't mean that the federal government thereby gets to violate it. But nonetheless, as I said, despite the fact that many thought a Bill of Rights unnecessary, Madison and others became willing to include one as kind of a goodwill gesture. Right? As I said before, the lack of the Bill of Rights was a major source of criticism of the proposed Constitution by a number of what were called anti-federalists during the ratification debates. And so Madison and others saw that including a Bill of Rights could help win over anti-federalists to the Constitution. And that this talk actually began even before the Constitution had been successfully ratified. Many state conventions made it clear that they were ratifying the Constitution with the expectation that a Bill of Rights would be added. And Madison obliged them during the first session of Congress. But here is an important thing to note about the Bill of Rights. Remember, most states already had bills of rights in their own constitutions. And as originally understood, the Bill of Rights in the federal Constitution applied only to the federal government. The Bill of Rights in the Constitution was not understood to be placing any limitations on the state governments. The Bill of Rights was not understood to apply to the state governments at all. Right? The relevant Bill of Rights that applied to the state governments would be whatever Bill of Rights was included in the state constitution. But the Bill of Rights applied only to the federal government, right? Remember, the First Amendment says Congress shall make no law respecting an establishment of religion. So it applied only to Congress, right? State governments could if they wanted to. Massachusetts had a state church, right? So it was really only in the 20th century and under the authority of the 14th Amendment that the Supreme Court began to apply these restrictions to the states as well. And in the packet in this section of the course of tables from the Jim Caesar American Government textbook, there is a page that gives a list of the cases where certain aspects of the Bill of Rights were first applied by the Supreme Court to the states. So you can look there for that information. Now, just kind of following sort of conventional political science, the Bill of Rights, generally speaking, guarantees two different kinds of rights: substantive rights and procedural rights. Substantive rights, this specifies certain domains of individual or state freedom, areas where you are free to act according to your judgment. So freedom of speech. So the substantive rights forbid Congress from making laws limiting personal liberty, whereas procedural rights are meant to protect citizens from illegal or arbitrary governmental action. So there are particular substantive rights, things you have rights to, and then there are the procedural rights, which are more about rights that have to do with the rights you have when you are, undergoing criminal investigation or what have you. So things like, the right to trial by jury, the right to a public trial, and things like that. And so these procedural rights are there because they're necessary rights for individuals to have so that they can be assured of fair treatment in the legal system. And so if you look at that under those categories, then when it comes to substantive rights, you've got the First Amendment: free exercise of religion, free speech, freedom of the press, freedom of assembly, freedom to petition the government. Second Amendment, you've got the right to bear arms. Third Amendment, there's no quartering of troops in private homes during peacetime. Right? That's meant to protect your property. And then you've got the Ninth and the 10th Amendment saying just because a right isn't on this list doesn't mean you don't have it. And the federal government is limited to enumerated powers. So those are all substantive rights. Then you can talk about other ones where you've got procedural rights. So the Fourth Amendment, an important one: no unreasonable searches and seizures. Police have to get a warrant issued by a judge to search a specific place for a specific item, right? So they've got to get a warrant. Searches of people or movable property didn't require a warrant, but they had to be reasonable. There had to be some evidence that a crime had been committed. The police couldn't just randomly start frisking people just to see what they could find. So the government can't arbitrarily search people. They have to have a motive. The Fifth Amendment, very important. This amendment covers criminal procedures, your rights when you are accused of a crime. So you have a right to a grand jury for capital trials, that is, trials for capital crimes, to ensure that the state has some potential evidence against you. There's no double jeopardy, right? If you're tried and acquitted, the state can't charge you and try again. And also, you have the due process clause. You cannot be denied life, liberty, or property except by due process of law. So, in other words, that if the state deprives you of life, liberty, or property, it must be because that is a legally mandated punishment for some infraction that you have been found to have committed through a fair and open legal process. You also have the right to equal protection of the laws, right? Nobody's above the law, nobody's below the law. The laws must be equally applied to all. The Sixth Amendment gives you the right to a speedy and public trial in criminal cases, the right to an impartial jury, the right to legal representation. And this is to make sure that if you're accused of a crime, you can get a fair trial, not a secret one or a biased one or one where you don't have a chance to make your case or call witnesses or question the witnesses of the other side and all of that. Seventh Amendment gives you the right to a jury trial in civil cases, so not a crime, but where you're being sued by another citizen for some infraction. And again, this is the Seventh Amendment is to make sure that you have a chance to assert and defend your rights in court. And then in the Eighth Amendment, no excessive bail or fine and no cruel and unusual punishment. So that's the Bill of Rights. Then you have the next big batch of amendments are the Civil War amendments, the 13th, 14th, and 15th Amendments. So really, whereas the Constitution originally protected slavery in any state that chose to allow it, right? With the 13th Amendment, slavery is done away with. And also through the 14th Amendment, this is the first time where the federal government is explicitly given the power to protect the rights of ex-slaves if the states fail to do so. And the 14th Amendment, it's actually the 14th Amendment which applies to the states that provided the legal rationale for the Supreme Court eventually expanding the other parts of the Bill of Rights to apply to the states too. So the 13th Amendment, what does it do? It prohibits slavery, right? Neither slavery nor involuntary servitude, except as a punishment for crime or if the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And notice Section 2. Congress shall have power to enforce this article by appropriate legislation. What's the purpose of that being in there? Well, it's something like a necessary and proper clause. Because the Constitution is based on the principle of enumerated powers, and since the Constitution does not explicitly give Congress the power, for example, to conduct investigations to make sure that masters have freed their slaves, Section 2 of the 13th Amendment says Congress can pass whatever laws it needs to in order to make sure that the states are abiding by this amendment. Things like that weren't necessary with the Bill of Rights because the Bill of Rights didn't apply to the state governments. So there was no need for Congress to have the power to make sure that states complied with it because the Bill of Rights wasn't meant for the state governments. But the 13th Amendment is. The 13th Amendment is saying states can't have slavery anymore. Well, what happens if, a former Southern state doesn't want to give up the institution of slavery? Well, Section 2 of Article 13 of the 13th Amendment says Congress has the power to make whatever legislation is necessary to force the states to comply with the 13th Amendment. Now, moving on to the 14th Amendment. The 14th Amendment, as I said, is a very important amendment. It says in the main section, Section 1, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So in other words, former slaves are declared citizens, and it says, no state shall make laws abridging the privileges and immunities of citizens, right? No state not just the federal government, but no state shall deprive a person of life, liberty, or property without due process of law. So in other words, without proving in a fair trial that the person had violated a known law that they can be punished for. So remember, in the Fifth Amendment, which applied to the federal government, it was the federal government that was constitutionally prohibited from denying due process. Now, with the 14th Amendment, the Constitution explicitly prohibits the state governments from doing the same. So in the same way, the Fifth Amendment had said that the federal government cannot deny people equal protection of the law. So the 14th Amendment says no state shall deprive a person of equal protection of the law. The law should be enforced equally without regard to age, color, sex, etc. So this is meant to provide, also with the protection of privileges and immunities. This is meant to protect the equal citizenship of all, including former slaves. So this is part of getting rid of the institution of slavery. And again, since they anticipated that Southern states would not be eager to do this, you have Section 5. There are other things in here, but we don't need to get into it. But Section 5 of the 14th Amendment, which says Congress shall have the power to enforce by appropriate legislation the provisions of this article. So in other words, again, Congress has the right to make laws to compel the states to honor the 14th Amendment. So the 14th Amendment is an example of a place where the federal government is given the power to sort of put the states on watch. And this is why eventually the 14th Amendment becomes the basis for arguing that other amendments, like the parts of the Bill of Rights, also restrict what states can do. So whereas the First Amendment was originally understood only to bar the federal government from establishing a church, but to leave state governments free to establish a church, the First Amendment, the language is, the First Amendment became incorporated into the 14th Amendment, which applies to states. And now the First Amendment is understood to apply to state governments as well. So not only the federal government, but state governments cannot establish churches. That's a 20th century innovation in legal interpretation. Some people dispute its validity. That's how it happened. Now, there was one more Civil War amendment, the 15th Amendment, which says the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So in other words, ex-slaves and non-whites must be given the right to vote. And as we know, it took over a century for this amendment to be put into full effect through a series of civil rights acts. So these things were in the Constitution, but in fact, they oftentimes were not honored. Now, as for some other amendments, you've got a few that are from the progressive era in the early 20th century. So the 16th Amendment makes it legal for the federal government to have an income tax. Under the original Constitution, the federal government was not allowed to tax people at different rates on the basis of income. The 16th Amendment makes it possible for the federal government to tax people at different rates depending on their income. So people with a higher income have a higher tax rate as well. So that's 1913. The 17th Amendment, also 1913, is what made senators popularly elected. That was a big progressive movement, desideratum. 18th Amendment, if I remember right, is prohibition. Although that doesn't seem right. Let me check, since I've got the book right in front of me. The 18th Amendment is prohibition. The 19th Amendment, which is 1920, the 19th Amendment is women's suffrage. So by the 19th Amendment, it's no longer the case that states are allowed to prohibit women from voting. The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. So those were all things, including prohibition. Those are things that all come out of the progressive movement. The 22nd Amendment from 1951 is when the Constitution is amended to officially limit the president to 2 terms. And then you have a few amendments that are part of come from out of the civil rights movement. So the 24th Amendment forbids states from having poll taxes. A poll tax is basically a tax on voting, so that in order to vote, you have to pay a tax. Since African Americans were oftentimes quite poor in the South, poll taxes, which the Constitution had not previously forbidden states from charging, poll taxes oftentimes were a technique that was used to disenfranchise African Americans by making it basically too expensive for them to vote. And then the 26th Amendment, which also comes out of the time of the Civil Rights Movement, makes it so that once people are 18, they must be allowed the right to vote. Prior to that, I believe it was up to each state government to determine what the voting age was. And so the norm at that time prior to the 26th Amendment was that you had to be 21 to vote. And the 26th Amendment comes as a response to Vietnam, the war in Vietnam, and the draft, with the kind of logic being, if you can be drafted at the age of 18, in other words, if at 18 you were old enough to fight, why are you not old enough also to vote for the people who might send you to fight? So the argument, the fairness argument was basically, if you can be sent to fight, if you're mature enough to fight, then you're mature enough to vote. And so that's the 26th Amendment, which is not a civil rights movement thing per se, but both the 24th and the 26th Amendments, it really can be seen as kind of coming out of the social change of the 1950s and the 1960s. There are other amendments, but we don't really need to talk about them. So with that, we conclude the series of lectures on the original Constitution and the amendments to it.